Wealth, a video blog on topics of interest in taxes, estate planning, and business planning. Today we're going to be talking about estate planning, and we're going to be talking about one of the 27 trusts known as an irrevocable trust. Now, a reminder, what's a trust? It's a relationship between a grantor, a trustee, property, and a beneficiary. The trust is the holder of assets, and the grantor contributes property to the trust. The trust holds legal title in the name of the trustee, who is responsible for managing the assets for the benefit of a beneficiary. Simple as that. Now, again, there are 27 kinds of trusts, and today we're talking about irrevocable trusts. Last time we talked about revocable trusts. Irrevocable, it implies that it's set in stone. It can't be changed, but nothing is written in stone. Even today, under our laws, you can change a revocable trust, and I'm going to talk about how you can do that. What's the difference between revocable and irrevocable trusts? Well, a revocable or revocable trust can be changed at any time. It provides minimal asset protection, and any assets in a revocable trust will be included in the estate for estate tax purposes. It's also the most flexible form of trust. An irrevocable trust, by contrast, generally cannot be changed, but I'll show you some ways to get around that rule. It also provides significant asset protection from creditors of the beneficiaries and the trustees of the trust. It also can provide estate and income tax planning benefits that are not otherwise available in a revocable trust. And it also can provide flexibility, or it can be very rigid and cannot provide flexibility. In an irrevocable trust, the grantor, the person who creates the trust, gives up legal ownership of the assets that he puts or she puts into the trust. The trust or the trustee holds legal title to these assets. The trustee controls them for the benefit of the beneficiaries, who are said to hold equitable title. Generally, in an irrevocable trust, the terms cannot be modified, amended, or terminated, so that it retains the intent of the grantor when he or she contributed the assets to the trust. If it cannot be changed, in some cases it may lead to unintended results. So we may want to be able to change the trust by decanting the trust, literally pouring some or all of the assets into a new trust for the benefit of the same people. You have to be very careful, though, that state law allows you to do this, and it does not mess up the tax treatment that you've originally anticipated when you set up this irrevocable trust. Another way of getting around irrevocability is to enter into a non-judicial settlement agreement. In uniform trust code states like Virginia, Maryland, DC, Florida, and 21 other states, you have to look at state law, but a non-judicial settlement agreement generally is available. It allows you to reform the trust without involving a court. Before the grantor's death, you need the consent of the grantor, the creator of the trust, the trustees, and the beneficiaries. In some cases, the courts will allow the reformation of a trust in a non-judicial settlement agreement after death, and you may even be able to do this without court involvement. In that case, you would get the consent of the trustee and the beneficiaries. In some cases, you may need to get a creditor's consent depending on the facts. If you've got questions about irrevocable trusts in general, send me an email to wayne@zelllaw.com or visit my website and content sites for more information. Thanks for tuning in to Blueprint for Wealth.